greetings and welcome to yet another edition of BWF Solicitors podcast. Today we are discussing illegal evictions and harassment. So we said you should find your rights. Now, your landlord must follow strict procedures if they really want you to leave their property, depending on the type of tenancy agreement you have and the terms of it. So if they do not, then they may be committing an offense. Before we look at how your landlord should go about to actually get rid of you legally, we should look at what tenancy agreements there are, and therefore to be able to exactly point you to what requirement that have to be met for your landlord to get rid of you. So for example, let's look at an assured short hold tenancies. That's the most common tenancies that we have in England. Now, if you have an assured short hold tenancy and your landlord would want to evict you, the landlord will first have to give you a notice. Normally, the law says that the notice should be at least 6 months, depending on the length of your tenancy. So 2 months is the least that he or she should give to you. Now, once that notice has been given, it doesn't have to be in writing, it can be oral, but for litigation's sake, if a landlord is giving a notice, that should be in terms of assured short hold tenancies. Section 21, that is Section 21 of the 1988 Housing Act says that a landlord must give a reasonable notice and that will meet the requirements. So Section 21 or Section 8 notice. The difference between the Section 21 and Section 8 notice is that the Section 21 means the tenancy has come to an end and the landlord is not willing to extend it and therefore will require his or her property back. Then he or she can issue Section 21 notice. Section 8 is whereby there has been a breach of the agreement of the tenancy agreement. So if there is a breach in contract and therefore the landlord would want to repossess his or her property, he or she will give Section 8 notice of the same act. Now, the process. So you have been given a notice to leave. Normally, you don't necessarily, a tenant, have to leave at the end of the notice period. If you don't leave, then the landlord must go to court and get a possession order to get rid of you. We are talking about legal eviction, and therefore, if the landlord fails to follow these procedures, he or she may be committing a crime. So there is a notice, and the notice has come to an end. The landlord has gone to court and got a possession order. Even with the possession order, you may not have to leave your property because the law says that the landlord must go back to the court for a warranty. So a warrant would permit the landlord to secure the services of, let's say, bailiffs to get your belongings out. So 3 things. There is a notice for you to leave, and there is a possession order, and there is a warrant for you to get out of the property. If these 3 requirements are met, then there will be a legal eviction. Having said that, a landlord may not have to follow these requirements to get rid of you, and it will still be legal. So for example, if you are an excluded tenant, the meaning of excluded tenant is that you share common places in the house like kitchen and bathroom with the landlord. If that is the case, then unfortunately you will not be protected by what we've just explained, and therefore a landlord can actually just give you a notice and at the end of the notice period ask you to leave the property. If you do not leave the property, the landlord can actually change the locks and secure his or her property and exclude you by not gaining access to the property again. So that's the difference. The protection for people that are with their short hold tenancies are different from a person that is an excluded tenant. So we should make sure that we know these things. Now, we talked about harassment. What will constitute harassment and what's the definition of harassment? Anything that will cause you not to enjoy the home that you have rented can be said to be harassment. And what can you do if you have suffered harassment from your landlord? You can just speak to your council, and then your council will be able to step in and support. So for example, if your landlord has cut services like gas, water, lights, that is harassment, because then it would interfere with your enjoyment of the property. So you have to first contact your local housing authority, and then they have an illegal obligation to intervene by making sure that those services are put back, and if they are not, the local authority can take action on your behalf and litigate to get you the services put back and get compensation. So in summary, if you are a tenant and you are looking into getting support from a council and you want to make sure that your eviction has been legal and therefore you have become homeless not intentionally, then you have to make sure that the landlord followed the required procedures as I have outlined, and therefore you will be considered as a person who is homeless legally and can get housing support. So landlords and tenants, this is for you. If there should be any further queries or outstanding questions, please do not hesitate to contact us on our office line, that is 020-8493-7340. That is 020-8493-7340. We will be happy to help. We will come back next week with another exciting topic. Take care.